Imagine you start noticing subtle signs. Your mom has unexplained bruises, your dad seems withdrawn, and the care staff always seems too busy to answer questions. You want to believe it's nothing, but what if it's not? What if the people you trusted to care for your aging parents are actually causing harm and no one's being held accountable? Sadly, this happens more often than we think, but families do have options. And that's exactly what we're talking about today. I'm Dale Corpus, a senior transition specialist and real estate expert based in the San Francisco Bay Area, and also a proud member of the sandwich generation, juggling care for aging parents while raising my own family. I know firsthand how overwhelming senior care decisions can be, and that's exactly why I started the Simplify Senior Transitions podcast, to make these conversations easier, more accessible, and less stressful for families like yours. In today's episode, I'm excited to welcome David Kleczek, a highly respected trial attorney and founder of Kleczek Law Office, who has dedicated his career to fighting for the rights of injury victims. David has represented countless clients in personal injury and wrongful death cases, and he has a strong track record of achieving justice for those who need it most. We're diving into a really important topic today: what families need to know about elder abuse and neglect, especially in senior living communities, nursing homes, and care facilities. David's going to share what warning signs to watch for, what legal steps families can take if they suspect abuse, and how to protect your loved ones from ever experiencing it in the first place. His passion for protecting seniors and holding bad actors accountable really shines through his work, and I'm looking forward to this conversation. Let's dive in.
Welcome to the Simplify Senior Transitions podcast, where we help families navigate senior living, real estate, and everything in between. Hosted by Senior Transition Specialist Dale Corpus, this show brings you expert insights, real solutions, and stress-free strategies to make senior transitions simple. Ready to dive in? Let's go.
And we're back. David, thanks for being on the show today. How are you?
I'm doing great.
And so let's just jump right into this. So can you share a bit about your journey and what led you into elder neglect and personal injury law?
Yeah, so my father's actually a lawyer. I grew up around him trying cases. He represented much the same type of people I did: injured people, people in bad situations. And in college, the one thing I knew was that I wasn't going to be a lawyer. And so I ran away from it for a little while, and I worked in the business world. I did some consulting after college, and I realized that trying to help businesses save a buck wasn't my gig.
Okay.
And I went to law school and got a job at a high-rise in downtown Chicago, and that was my dream. And then I realized there's more to this. And so I actually started working with my dad, and it was the greatest experience ever. He taught me more than I could have learned in law school. So full circle, I tried to resist, but here I am, and I love what I do. And I love helping people doing good and doing well. That's what.
Well, it looks like you got really good one-on-one coaching from your dad. And side note, the apple doesn't fall that far from the tree. So what types of cases do you see most often when it comes to elder care?
When it comes to elder care, it's very sad. It's people in bad situations. They don't have time to be there with their parents. We live very busy lives. It's hard to maintain. And basically, we see people after the fact. And we see people whose parents either have been deceased and they're looking into why, or whose parents are just in very, very bad shape and they don't know what to do. They don't know what to do.
Okay. And why is it so important for families to understand their legal rights when a loved one enters care?
Well, and let me just say, I have to give the caveat. Anything today is not legal advice. Every situation is different, and you should always consult an attorney. And any conversation we're having today isn't the formation of an attorney-client relationship. But knowing your legal rights is the first step to prevention.
Okay.
And nobody wants a lawsuit. You don't want to be in that situation where your loved one is either injured or has passed away.
Yeah.
Money's not worth it. You want to know your rights so that you can stand up to the nursing home, either move your parent at the appropriate time, spot the signs of neglect and get them out of the situation, or tell the nursing home, this is what we need to do. And knowing that is half the battle. Really, you need to be an advocate for your parents or your loved ones.
Okay. Let's talk more about that. Let's talk more about spotting neglect and abuse. So, what are the most common signs of nursing home neglect or elder abuse?
The most common signs are bed sores,
Okay.
pressure ulcer, and just a decline, a cognitive decline, confusion in your parents, which may represent not getting enough liquids, not getting enough nutrition, not getting enough activity.
Okay.
Other signs would be staff turnover and using common sense, seeing staff that aren't sanitizing at the appropriate time, not using proper PPE. You're noticing the bed sheets are dirty. You're noticing you go use the restrooms dirty. So these are just signs that you can tell. If you think something's wrong, something is probably wrong. Where there's smoke, there's fire. So it's a lot of it is common sense, but we don't want to believe that something is wrong. Most people want to trust that the experts are doing their job.
Yeah. On a related note, are there early red flags families should watch for either in a facility or in how staff interacts with residents?
Well, you definitely want to make sure that the house staff is attentive.
Okay.
If you see your parent or your loved one experiencing fearfulness, if you see high turnover, if you don't see the same nurses at the same time on a regular basis, perhaps it's got a high turnover and they're not getting the appropriate care. But the big threes that to watch for is pressure ulcers, hip fractures, and pneumonia. Generally, those three are the result of negligence. Pressure ulcers should never happen. It should never happen. If your loved one is being taken care of properly, there's no excuse for a pressure ulcer, for a bed sore. They need to be attended to. Hip fractures are usually, especially multiple hip fractures, the result of a person not having adequate fall prevention. And pneumonia is commonly from malnutrition.
Okay.
So if you spot those, then it's time to dig deeper.
Okay. Now, what kinds of injuries or incidents trigger legal action most often?
So basically what brings people to talk to a lawyer is when things are really bad. And a lot of people resist talking to a lawyer. They say, a lot of people say, well, I don't want to bring a lawsuit. Well, I'll tell you something. You can talk to a lawyer regarding these for free.
Okay.
And you're just getting advice. Talking to an attorney is just getting advice. And you can talk to them about your situation and they will give you advice. Most lawyers I know, especially lawyers that do this kind of work, are happy to give you a free consultation.
Okay.
And you don't have to sign a retainer. You're not bringing a lawsuit. It's just getting information. And sometimes it's just a matter of knowing your rights and going back to the care facility and telling them what they need to do. Maybe you need to switch care facilities.
Okay.
But what brings people usually is when it's too late,
Right.
unfortunately.
Right. Now, how can families document potential neglect before it's too late?
Yeah, so everyone has a cell phone, and you take pictures. You take pictures of the conditions. Make sure that they have the timestamps. All the cell phones have the timestamps. You can walk into the loved one's room, take pictures of the chart. It's right there. You can take pictures of the chart. But documenting the condition of the home, the condition of your loved one is very important. Because ultimately, if you do need to bring a lawsuit, then the burden of proof is on the person bringing the lawsuit. Meaning, you have to show, and sometimes by a preponderance of the evidence, a higher standard than in normal civil cases, that the nursing care facility was acting with malice,
Okay.
with fraud, with neglect. And to do that, the nursing home's going to do everything they can to hide after the fact. They may destroy records. They may lie, cheat, and steal. And I am in the trenches, so I get jaded sometimes. And I'm not saying that this is the norm. Most people working in nursing home facilities are very good people, and you normally get very good care. When I get involved is when they're not.
Okay.
And under those circumstances, a lot of nursing home facilities and care facilities are trying to sweep things under the rug. So your phone is a great way of documenting. You also can call the California Department of Public Health and you can file a complaint and they will do an investigation. And that is really, really good evidence. There's many cases I've had when the California Department of Public Health has come in, they've done the investigation, they've documented everything I needed for the case. And the case is laid out for me. And that information is not going away. Not only does it help the case, but it helps the others in the nursing and long-term care facility, because the facility is going to have an action plan after that. They're going to be watched by the various agencies. So those are the two best ways: is to document your phone and to contact California Department of Public Health.
Okay. Now let's segue into legal recourse for families. What should someone do immediately if they suspect abuse or neglect?
You need to get your loved one out of that situation immediately. Move them to a different place. You want to request their medical chart within 24 hours. You want to get that chart right away before they have time to come in and make changes. It happens. Charts sometimes are forged. So you want to get that chart. And you want to file a complaint with the ombudsman, the California Long-Term Care Ombudsman. And you can find that phone number. And most states have them. California, you can find the phone number online or submit an online complaint.
Okay. What does the process of pursuing a case typically look like?
So pursuing a case, the first is you contact the lawyer. From my perspective, we do an intake. We talk to the clients. We find out what the situation is. The second step we do is a record hold letter. We send out letters to anybody and everybody that might be involved, telling them to keep the evidence, don't change the evidence, don't get rid of the evidence. The third step is, because these are technical facilities that are subject to standard of care, various federal and state laws, we run it by an expert. And it depends on the situation. Was this a medical situation? Was this a neglect situation? Was this an understaffing situation? And then we find the various experts and we have them review it. And because we want to make sure, I'm an attorney. I can look at something and go, well, that seems like neglect, but I may be wrong. So I want to have that expert ready. And then we usually will make a pre-litigation demand. We will see if there's a willingness to settle the case without having to file a lawsuit. And that takes a lot of stress out of the situation for our clients. But that can be successful under very egregious situations. But a lot of times, long-term care facilities will fight. They don't believe they did anything wrong. Right. So a lot of times we have to file a complaint. Filing a complaint brings the case into court. And at that point, we do what's called discovery. Discovery is just like it sounds. You're discovering the facts. Each side sends questions to the other side. We have to answer them under oath. We ask for documents from the people that we sue. They ask for documents from us. We, after the written discovery phase, we do depositions. A deposition is a question-answer session under oath where I can ask the staff at the nursing home questions. The lawyers for the nursing home can ask my clients questions. And after that, usually we have a timeout in the case, and the courts require us to sit down and try to resolve the case. Once the facts of the case are known to everybody, the lawyers will look at the case and say, well, maybe we can resolve this. And that helps. That helps. Most cases don't go to trial. That's the last resort. 97% of all cases settle without a lawsuit. That means 3% go to trial. Which 3% go to trial? I don't know. I can't guess which 3% are going to trial. So I prepare every single one of my cases as if we're going to trial. And what that does is that results in getting the best settlement, because defendants, long-term care facilities, doctors, nurses, they will hold out until they think, oh my gosh, this person is going to go to trial and I'm going to get killed. And once they recognize that, then they will come to the table in a meaningful way. So you first have to jump through all these hoops. A lot of times, once the facts are known, the cases a lot of time will settle. The 3% of cases that do go to trial are usually a failure of one or both parties to recognize the weaknesses in their case.
Gotcha. Now, for my knowledge, because I don't know the answer, what's the statute of limitations for filing a case in California?
Well, the statute of limitation for every situation is different.
Okay.
Physical neglect cases, it's 2 years. Medical malpractice cases, it's 1 year. Financial abuse, it's 4 years. So it's important to talk to an attorney as soon as possible and have your situation analyzed. And in fact, if you're staying at a state or county facility, the time frame to file a claim can be as short as 6 months. So you really need to talk to somebody right away. Again, talking to a lawyer doesn't mean you're bringing a lawsuit. It just means you're getting information, and information in every situation in life is key. So, you don't want to be talking to the attorney 2.5 years after it happened because you were on the fence for a year.
Yeah.
Once you recognize, just talk to the attorney, then it's a 2-year statute of limitations. It's a 1-year statute of limitations. And then you can make a knowing decision as opposed to regretting not talking to an attorney.
All right. Yeah, that's solid advice. Thank you. Now, can you share a case example confidentially that illustrates a successful outcome?
Yeah. And this is a case that happened during COVID.
Okay.
And it's actually the daughter. It's a sad case. They're all very sad cases. The daughter was a daddy's girl, but she was also a nurse. And her father had a stroke, and he went into the hospital, and he was recovering slowly. He had some communication issues, but he was unable to care for himself, so they needed to send him to a long-term care facility. And the insurance company was being a little cheap. I don't know if anyone's ever experienced this, but the health insurance company was offering what she thought were subpar facilities. And she's an educated person. She pushed back a little bit. They wanted to send her father way down to Fresno, and she's saying, I live in the Bay Area. That's a 3-4 hour drive. They found a place outside of Sacramento, which is a little better, and she would go as much as she could. And when she would go, she started noticing that the staff weren't using the proper PPE, and she started documenting this. And she filed a complaint with the ombudsman, and there was an investigation, and they came in. And when they came in, they noticed the staff not wearing the proper PPE. Now, unfortunately, before the state had been able to come in and do their investigation, an infection came in. 55 out of 84 residents came down with COVID, and there were several deaths as a result. It was like 20 of them had passed away. The state had found that they were caused by the failure to wear the appropriate PPE, the failure to follow the proper protocols. And so this person came to us, and she did everything right. We had everything we needed. And these are difficult cases. Whatever you think about COVID, the fact is PPE or no PPE, we don't know everything about it. We didn't know everything about it at the time. Proving that type of case is very difficult. But because our client had the knowledge and the wherewithal to do her investigation and get us the evidence, we were able to get a great result on that for her. Her father passed away. It's tragic. And most people don't come to us and say, I want to get a boatload of money. Most people come to us and say, I want to do this because I want to make a difference. And she made a difference, and this care facility is better for it. I look at what we do in this business as a way of making corporate actors act responsibly. We make changes. We change the way people act. This is the ultimate personal responsibility, is allowing lawsuits. However you feel about lawsuits, people don't want to get sued. So they do things to avoid lawsuits. And long-term care facilities follow protocol to avoid lawsuits.
Gotcha. How do you families emotionally through the legal process?
Well, we are psychiatrists and lawyers, we're counselors. So we listen. We have empathy. That's what we can do, is listen to what they say, understand. I get to know the people I represent. I will have lunch with them. I'll have coffee with them. Spend time with them. I want to know all the children of a loved one who's passed away. I want to meet all the children. I want to meet the grandchildren. Understand the family dynamics. I want to know the last family reunion you had, what you did, what types of things the family did for fun. And people, I think, appreciate the genuineness of wanting to get to know them.
Yeah.
And they appreciate the ability to talk about something. And they appreciate the ability to actually make a difference for somebody they loved who may have been lost or has seriously been affected in their quality of life.
Excellent. Now, I want to pivot a little bit. Let's talk about wrongful death in elder care. What makes a case legally qualify as wrongful death in the context of senior care?
Every case, elder care involves a person that qualifies as either over the age of 65 or is unable to care for themselves. So you can be 30 and still fall under the protections of the elder care statutes in the state of California,
Okay.
so long as you're unable to care for yourself. And if you're subject to physical, emotional, or financial fraud, and if the physical or emotional is a result of fraud, malice, neglect, then you are entitled to bring a lawsuit for elder care, for violation of the elder care. And that entitles you to cover punitive damages in some cases. So you can prove fraud, malice, or neglect. It entitles you to recover your attorney's fees. Now, let me just step back. Most lawyers, a lot of people say, well, I don't have the money to pay a lawyer to look into this. Most lawyers, as a matter of fact, every lawyer I know that does nursing home cases does these on a contingency fee basis. What that means is our fees are contingent upon recovery. You pay nothing unless and until there's a recovery. Even if you lose, you don't owe any money to the lawyer. If the lawyer and you are able to prove an elder abuse case, the lawyer can go and collect the attorney's fees from the other side. The percentage that you would have paid them, collect from the other side. So that's an incentive that the state of California has given, have people self-report, to have a system where it's self-governing. So elder care can result in financial abuse. Your loved one has lost his or her nest egg, has no money, but that person's still alive. And so you can bring a lawsuit on behalf of that person. But elder care can also be caused by neglect, physical neglect, not taking care of a person, and the loved one dies. And that is a wrongful death case. It's a wrongful death case under the elder care laws. And so you can have the people who are entitled to bring a wrongful death case are the heirs of the loved ones. And the heirs, a lot of times, it's clearly the children of the individual. Sometimes it's the grandchildren. It really depends on the situation. If the loved one has no children, perhaps it's a brother or a parent is an heir. If you have a child that is disabled and they're in a long-term care facility and unfortunately something happens to the child, the parent is the heir. So the heirs are the ones that bring the wrongful death claim. And we're getting a little bit in the weeds here, but let's say your loved one has been subject to physical and emotional abuse for a period of 6 months and then passes away. So your loved one has suffered greatly during the 6-month period, but then they pass away. What happens to their, what we call their damages? Yeah. Well, it survives the death of your loved one. Okay. Meaning the heirs can recover for the emotional distress, pain, and suffering that your loved one suffered during the 6-month period, but they also recover for the loss of society, the loss of companionship that your mother, father, child, loved one provided you. And these are very nebulous in terms of, well, what is loss of society? What is loss of companionship? And ultimately, it is up to a jury to decide how much award in a case, how much justice demands. And that is all over the board.
Yeah.
Some juries say, well, I don't believe in giving money for somebody you lost. Other juries will be able to put a very large price tag on it. Oh, this is another reason cases often settle, is because of the ambiguity and the uncertainty of going to trial. You don't know who you're going to get in your jury. But I do tell people that if you are ever, and this is my public service announcement for the day, if you're ever called for jury duty, that is going to be the most impactful vote you are ever going to have, because you can change people's actions by rendering a jury verdict. So your opinion is important. Go. It is a big commitment, but it is our civic duty, and it's one of the things that I think makes this country great. But, beyond that, the wrongful death damages and the personal injury damages that you can recover, sometimes in some cases you can get punitive damages.
Okay.
So the law has two buckets of damages you can collect in a civil case. Compensatory damages are designed to compensate you for your injuries. The focus is on the injured person, the injured party, compensate the family for their injuries. Usually the criminal courts are designed to punish somebody that has done something illegal, to put them in jail, to fine them. That's what the criminal courts are for. But sometimes in the civil realm, we are able to prove that the nature of the action was so bad that we need to punish the other side, and that's what punitive damages are. And then we would look to the nursing care facility and say, what is it going to take to punish you so you don't do this again? So you look to the actual damages the family suffered, which can be medical expenses, lost wages, pain and suffering, emotional distress. And if it's a really bad situation, you'll say, you know what, long-term care facility, what you did was so bad. In addition, we're going to punish you, and you need to pay an additional amount.
Got it. For my clarification, how do these cases differ from other types of personal injury litigation?
Well, the significant differences are that the people we're representing are often, they don't have a voice.
Okay.
And we're relying on what loved ones saw. We're relying on medical records. We're trying to read the tea leaves. So there can be proof. That's why it's important when you go in to document what you see. If you think something is wrong, something probably is wrong. It at least should be investigated. So we're sort of at a disadvantage then if somebody who is in a car accident comes in and says, hey, I was driving on the freeway and somebody hit me from behind. It's pretty cut and dry. But a loved one comes in and says, I don't know what happened. She was doing great. All of a sudden I got a call and she had suffered cardiac arrest. And by the time I got there, she was gone. We don't have a lot to go on at that point. We need to get the records. We need to try to find out what happened. So that's a big difference. The other differences are in the ability to get attorney's fees, which can really make a difference in getting an attorney to represent you. It is an incentive for an attorney. We are a capitalist economy, and we're not working for free. So the ability for an attorney to get attorney's fees, if they can prove their case, allows people to get good, solid representation. And it also, what's different than in a car accident case is we all drive down the road. We all know you stop at a red light, you follow the speed limit, but we don't all know the rules, regulations, and standard of care that a long-term care facility or a nurse or a doctor need to follow when operating one of these. So sometimes I have clients that come to me that think something was wrong, and I say there may have been, but I just can't prove it. I don't have an expert. And that is a significant difference. In a car accident case, you often don't need experts because we all drive every day. But in every long-term care facility case, we're going to need an expert to come in and talk to us about what the standard of care is. So those are the main differences that I can think of.
Got it. What are the most misunderstood aspects of wrongful death cases in elder care?
I would say people think it's a medical malpractice case. There have been limitations historically in California in the ability to collect damages in medical malpractice cases. And it was very, very, for many years, from I think it was 1979 all the way up until 2024, we were limited to $250,000 in pain and suffering damages. That has been changed. So medical malpractice cases, as of this year, you can collect up to $600,000 per entity. You could get up to, I think it's 1.8. Anyway, I'm getting a little complicated because if you sue 3 entities, you can get 600 from each of those. But a lot of people feel like they don't have a case, that it's going to be too hard to bring because there's limitations. But if you prove elder care abuse, those limitations don't apply. It takes it out of the medical malpractice rules. One thing that I always tell people is, and this goes for all my cases, this is not suits. We don't get a person that walks in and resolve your case in an hour. I have to tell my clients, I have to set expectations, and I do this early on. This is going to be a long process. If we're lucky, 6 months, but usually 2 years. This process is going to take 2 years, and it's nothing like suits.
Okay. Now, let's talk about choosing the right facility. From your perspective, what due diligence should families do before selecting a nursing home or assisted living community?
Yeah. So the Google search is the simplest way. Reviews are good. Just like when you're looking at a hotel, you disregard some of them. If it's a 1-star review and they're mad about something that doesn't seem appropriate, you can disregard it. If it's all 5 stars, they were happy. Who knows what prompted them to give the 5 stars? You look at the 2, 3, 4 stars and read what they say. And if it's a legitimate, or if they just have bad reviews, that could be a red flag. You can go to the California Department of Public Health website and you can do a search and find out if they have had inspections that resulted in what we call immediate jeopardy. An immediate jeopardy situation is where the inspectors have found something so bad that it has put the health and safety of the residents in immediate jeopardy. And these are all public. They're public 90 days from after the inspection, and you can find them online for the particular care facility. You can also go to CMS, the Medicare Services website, and you can do a search for your specific care facilities, and you can find the same reports there about it. You can go in and you can ask the staff about the hours of service per resident that particular care facility uses. And I believe the low-end standard in California right now is 3.4 hours per resident of nursing time that person gets there. So those are good ways of researching. You can also find out who owns that facility and look at what other facilities that person owns or that entity owns, because often they own many facilities. They're running many facilities, and they'll be running it the same way. So you can look at comparable facilities and do the same searches and find out what's going on there.
Okay. I'm so new at just understanding, navigating the legal system, but I have a related question to that. How do arbitration agreements or contracts affect a family's right to sue?
Well, that's a good question, and it's a hot topic. In 2024, the state of California said a long-term care facility cannot require you to sign an arbitration agreement. So if you walk in and they put an arbitration agreement in front of you, you can decline to sign it, and they cannot refuse care.
Okay.
So that's significant, but most people just sign whatever is put in front of you. I can't tell you how many clients I've heard that said, I didn't read it, I just signed it. So read what you're signing.
Yeah.
But you sign an arbitration agreement, it is binding and takes it out of a jury trial, but you still get a trial. The trial will be before an arbitrator who is usually a lawyer that is experienced in long-term care facility cases or medical malpractice cases. You still are going to get your day in court, so to speak. You're still going to get a decision, but there's a couple things. Arbitrations are not public information. The light of day is not shed on them. You're not going to be able to find all arbitrations against a specific place. The other thing is arbitrators are, and this is a fact, are more likely to dismiss a case than a judge, because judges are elected and they're held accountable by the public. And arbitrators are less likely to give large verdicts than a jury. You still can have a case, and if you can prove some serious wrongdoing, an arbitrator can be very fair at times and give you a significant verdict. It does not mean you don't have a case, but it can change some of the dynamics. As a lawyer, I will always examine the arbitration agreement, and there are ways to fight it. As a matter of fact, I'm fighting one right now. I just filed my opposition, and I'll be honest, I think the tide is turning a bit, and judges and the courts are less likely to uphold an arbitration agreement, and they're squeezing them a little more.
Now, are families often intimidated by the legal process? And if they are, how do you help them feel supported?
Absolutely, they're intimidated by the legal process. I tell families that I'm there for them, that I'm going to be with them every step of the way. I tell families that I've been doing this for almost 25 years, and I've helped thousands and thousands of people through this process. I explain the process. And again, knowledge is key. Once they understand what is going to be happening, it doesn't take away the nerves. If we go into a deposition and you're about to be grilled by another lawyer, it's intimidating. But I talk through the process. I talk through the questions I think may be asked of them. We do some practice questions. After good preparation, people are less nervous. And what really makes them feel better is I'm next to them. They're in a deposition. 90% of depositions are done via Zoom these days. I'm right there with them. I'm making sure the lawyer's not taking advantage of them, and I help them through the process. So that makes them feel better, but most people are very intimidated. Most of my clients have never been through litigation. And I mean, it can be a difficult process. So, you want to be ready for it.
What are common pitfalls that derail a case, and how can they be avoided?
Social media, pretending like everything is great, hiding facts, thinking I shouldn't tell my lawyer this. I mean, no case is perfect. There's no perfect case, but your lawyer is in the trenches with you, and your lawyer needs to know of the problems and pitfalls before it happens. Don't hide the fact that your father smoked for 40 years and have the lawyer find out in discovery, because the lawyer can deal with that later on. So we need to know what's happening. We need to know the good, the bad, and the ugly.
Okay. Now, going back to the topic of just protecting seniors, how can adult children proactively safeguard their aging parents legally?
Well, you want to probably talk to a probate lawyer, or there's a lot of tools online that you can use. And I'm not a probate lawyer, so this isn't my area of specialty, but you're going to want to think about a trust. You're going to want to think about how property will be transferred to keep it out of probate. You're going to want to have the right powers of attorney, a healthcare power of attorney. You want to have your directives in place. You want to talk to your family about end-of-life decisions. So these are things that can make a lot of these very difficult decisions easier on the family.
Yeah. Do you ever collaborate with fiduciaries or elder care advocates on cases?
Yeah, of course. Of course.
Okay.
Yeah, we'll consult with them.
Now, what drives you to keep doing this work, especially when dealing with such emotional cases?
It is emotionally tolling, but what drives me is the really justice, unfairness, is providing the individual that doesn't have a voice an avenue for their voice. And, my name is David, and I sort of take the David versus Goliath biblical story to heart. And I'm out there fighting every day. Sometimes I walk into court and there's 4 or 5 lawyers on the other side. It used to intimidate me, but now I relish in it.
Okay.
Really, what keeps driving me at the end of the day are my clients and helping my clients and just seeing the difference I can make both in the world and for my clients.
Awesome. Now, what would you say to a family who's unsure whether to pursue legal action?
I would say, and I've said this many times already, I would say calling a lawyer for a consultation is not pursuing legal action. And just know your rights, know the facts, know what the law is, and then you can make a decision. And I will tell you this, a lawyer is not going to take an unwilling person to court. There's so many bad things happening in this world. I'm not in the market of persuading people to go to litigation. I tell people what the facts are. And if somebody is hesitant or reluctant, I'm not bringing that person on this journey. But you want to make a knowing decision. And so if you decide not to go forward with litigation, do so your eyes wide open.
Perfect. Now, as we come to a close on this episode, what's one piece of advice every family should hear when it comes to protecting their aging loved ones?
Visit them often and keep your eyes open.
And lastly, how can people get in touch with you if they suspect elder neglect or have questions?
Give my cell phone number out to everyone, and you can call my cell. It's 309-208-6351. I think you've got my email address. You can put that in the notes.
In the show notes. And where are you based out of? I forgot to ask you that.
So my main office is in Oakland, California.
Okay.
And then the main office number is 510-663-7100. Email, call. You can text my cell. That's
Perfect.
the best way.
I'll have your website listed in the show notes. So, David, thank you so much for sharing your expertise and passion for protecting some of the most vulnerable members of our community. I truly appreciate the way you break down complex legal issues into clear, actionable advice that families can understand and use right away. Your commitment to justice, your compassion for your clients, and your relentless drive to hold wrongdoers accountable is inspiring. I know this conversation will give our listeners the tools and confidence to speak up and take action if they ever suspect something is wrong with a loved one's care. And for those of you watching or listening, if your loved one is considering senior living and you need to figure out what to do with their home, let's talk. Schedule a free consultation and learn more about my services at www.simplifyseniortransitions.com. Have a quick question, DM me on Instagram at SoldByDale. And if you found this interview helpful, please leave us a 5-star review on Apple Podcasts or Spotify. It helps more families discover the show. Like, subscribe, and share this episode with someone who might need this information. Thanks for tuning in. David, one last thank you for being on the episode with me today.
It was great. Thank you for inviting me.
You're welcome. And for everyone else, I'll see you on the next episode of the Simplify Senior Transitions podcast.